Hi, welcome to the podcast. I'm David Braddock, host of the Rise from the Ashes podcast, talking again today with Susan Mundahl. Well, Susan, here we are again. How's it going?
It's going great, David. What I want to talk about today is the 4 stages of divorce. And the reason I want to do that is because a lot of people come to me looking for a second opinion and they're in the middle of a divorce, but they have no idea where they are. No matter how complex your divorce is, there are 4 stages, distinct stages. And you should be able to figure out what each of those is based on what I'm going to tell you today. What I'm going to do is first just tell you what I believe the 4 stages are, and then let's just talk about each of those 4 stages.
So let's get it started. What is stage number 1?
Okay, so stage 1 I call service, and it's service of the initial pleadings. And pleadings are the summons and the petition and a couple other ones, but it is serving the other party that starts your divorce running. And so that's stage 1. Stage 2 is the discovery stage, and that's really important because that's where the parties lay their cards financially on the table and talk about the various issues. So discovery is stage 2.
Okay, and stage 3?
That's the mediation or negotiation stage. So we've collected all the information on the parties, and now we need to try and negotiate a settlement of their divorce. So that's the 3rd stage.
And stage number 4?
So stage 4 then is what I call preparation of the stipulated judgment and decree. Your marriage is a contract, your divorce needs to be a contract, and the best way to end your marriage is with the parties coming to an agreement on how they are dividing their property, how they're going to divide time with the children, and if there's any support issues.
Okay, 4 stages are the service stage, which is the summons and petition. Then comes the discovery stage, followed by the mediation/negotiation stage. And finally, there's the settlement stage, or in other words, the stipulated judgment and decree.
That's right, David.
Well, let's go back then to the service stage.
Okay, the most important part about this stage is it is service of the initial pleadings.
Okay.
What we call the summons and the petition.
And pleadings, just for the layperson who's listening, that is specifically papers that go to the court. Is that correct?
They are papers that are filed in district court, but they are served on the other party.
Okay, in other words, service.
Right.
Okay.
And the funny part is, in the best divorces, you don't actually serve the other side. The other side acknowledges that they received the initial pleadings. And it does start the 30 days running, the initial period of time that you have to serve an answer on the other side.
So once they have acknowledged service, there's a 30-day window in which the other side has to follow up with their answer, is what you're saying.
That's right, because if they don't do anything, as long as they've been served, in Minnesota, you can actually do a divorce by default, which is you go to the court and you say the other party hasn't served an answer within the statutory time, so now we can ask the court to grant us the relief we're requesting in our petition.
So if there's no answer given, is it all of the items that are in the summons and petition can potentially be awarded by default by the court? That's what you're saying?
That's what I'm saying.
Okay.
Yeah. I haven't included the answer. What happens in a lot of cases when both parties are interested in just having the divorce go forward, the other side is granted an indefinite extension to serve an answer, and instead we just work on the other stages to get to signing a stipulated judgment and decree.
Okay. That's if folks are getting along.
What it really is if folks are willing to be amicable.
Okay.
It's stretching it to ask divorcing people to get along well, I guess.
Okay. I suppose amicably will be where some things are settled in a way that everyone ultimately agrees to.
That's right. And really, in 95% of the cases, people do reach an eventual agreement to the terms of their divorce.
Okay. Let's say that we are into a regular form of a divorce process. What then happens at the discovery stage normally?
Well, discovery is really important because that's where both sides put out all of their financial information, and it really should be full disclosure. And that's of any non-marital assets they might have, and marital assets and liabilities. What we do is we prepare a spreadsheet, and that goes to the property division, but we also need to know what the parties are earning so that we can decide the amount of child support if there's children involved, and if there's going to be any spousal maintenance. So it is really important that we discover that information.
Okay. Please correct me if I'm wrong, but isn't the term full disclosure a part of the discovery stage? In other words, each side has to disclose what the parameters are for what their assets are, the things that they own either before their marriage and during their marriage?
Well, if they don't, the risk they run is that later on it could be that their divorce decree is attacked for fraud on the court. And so it is really important, I think, that each party go and lay all their financial cards on the table so that you know that the final stipulated judgment and decree, the contract, is going to be based on a fair and equitable division of the parties' assets and liabilities.
Whether it was before they got married or during their marriage, those are the things that are determined then.
That's right.
Well, then let's go on to that third stage, the mediation stage. Can you describe the parameters of that?
What I really should call it is alternative dispute resolution, because that's what the statute calls it.
Okay.
And alternative dispute resolution encompasses mediation, which quite frankly is the most often used. But there is also negotiation. Like if I'm representing one spouse and the other spouse is unrepresented, the parties have gotten together in a lot of cases and they say this is how we want it divided, and so we can go and prepare it. It's just negotiating. At the final analysis, it's just how do we come to that final agreement? Alternative dispute resolution is just the court's way of saying you need to attempt to try and settle this without court intervention.
Okay.
So that's why it is a really important stage, and quite frankly, I think it's a magical stage, because there are so many times when the parties are so far apart and we meet with a mediator, someone who is an experienced family law attorney or even a CPA if it's just a financial settlement.
Okay.
The magic that happens is the parties come to an agreement because they don't want to spend all of that additional time and money to go to trial and to hope that a judge is going to see the world their way. It's really important, instead of looking at fair and equitable. In fact, this one expert said that there's no such thing as fair because everyone thinks the only thing that's fair is they get their way.
Right.
So I like to say reasonable.
Okay.
It has to be reasonable, or better yet, it's something that both parties can live with. Divorce is really more about cutting your losses because it is more expensive for two people to live separately than it is for them to live together.
I see. And then we head into stage number 4.
Right, stage 4, and that's drafting of the stipulated judgment and decree. What it contains is stipulated findings of fact and conclusions of law.
Okay.
Now, findings of fact just means each of the categories that the court cares about. And again, I've listed those before. Those are issues regarding support, custody, parenting time of the children, and division of property.
And let me guess, we're talking about more pleadings.
Right. It is a pleading, and it's a long document, and even though I'm breaking it up into its components, it's just one long document that is usually around 15 to 20 pages when there are no children, and it's around 30 to 35 pages long when there's children involved.
Okay. And I know that we have discussed this on other podcasts, but let's, for the sake of making sure that it's understood here, what is the difference between this kind of a process and, it sounds like primarily, a settlement, settling for what's best for both parties, and a trial?
Well, it's the time and the cost. Going to trial is hugely expensive, and the courts expect the first 3 stages to happen.
Okay.
Although I get asked, people say, do we have to do mediation? And the answer is no, not if you've already reached an agreement.
Ah, okay.
So if you haven't reached an agreement, the courts expect you to attempt, and they call it good faith mediation, which means you both are going there with the expectation of trying to settle.
So whether there's ultimately a court case or not, there will have had to have been an attempt to try to do these first stages anyway. Is that what you're saying?
That's what I'm saying.
Huh.
Yeah, but if one party goes and files it in district court immediately, an extra step is the court set it on for an initial case management conference.
Okay.
And that's usually done within 60 days of the filing of the initial pleadings. Mm-hmm. And then the second one is after you've done mediation, if you haven't reached an agreement, then the courts will set it on for pre-trial and trial.
Okay.
We can talk about those another time, but just understand that once you start doing that, each one of those involves the court, and so it's going to be extremely expensive for the parties. And once you go to trial, you might be looking at experts, and trials can be hugely expensive.
Well, I must say, I really like the clarity that comes when determining what these 4 stages are. Is there anything else you'd like to add to this?
Yeah, quick quiz, David. What are the 4 stages?
Oh, let me see. The service stage, which is a summons and petition. Then comes the discovery stage. Then comes the mediation or alternative dispute resolution. How did I do on that one?
You did good.
Okay. And finally, the final pleadings. In other words, the stipulated judgment and decree that has been discussed and settled upon.
That's right. And I guess I should probably end by saying, once you have that signed document that both parties have signed and their attorneys, that document is then submitted to the local court. And the court then, if both parties are represented by counsel, then the court can go and simply review it. And if it looks fair and equitable on its face, then the court will sign it. The only difference is that if there are minor children and only one party is represented, courts will set it on for what's called a default hearing. And at the default hearing, the court will take the party, or if the unrepresented party also appears, and will take them through briefly the stipulated judgment and decree and ask them if they agree to the terms of it and they believe the terms are fair and equitable. And once the court determines that, then the court will sign it.
And it seems like if they're doing that, they're taking each point in that stipulated judgment and decree point by point as they're asking them. Is that correct?
They are, but they do it a little more. Is this your signature? Did you sign it? Do you believe it's fair and equitable? They don't take it agonizingly through 20 or 30 pages.
Okay. Well, there it is, the 4 stages of divorce. Thanks so much, Susan.
You bet, David. Have a good day, everyone.
You are listening to Rise from the Ashes, the podcast channel that takes a careful look at all things having to do with legal procedure within the family law process. Rise from the Ashes is sponsored by Mundahl Law, who specializes in assisting families and individuals through the legal process with respect, dignity, and caring. Mundahl Law is dedicated to helping people to solve their legal problems. You can visit the Mundahl Law website at mundahllaw.com or call to schedule a consultation with one of their qualified family law attorneys. Rise from the Ashes, focusing on matters of the family, because family matters.